There's some things when they happen in the news arena, we say, talk show hosts particularly, we say, boy, this is harvest season. And and I see my guest, Attorney Raphael Morgan, smiling because at the end of the day, there is a whole lot going on out there. You were admitted to the bar back in 2009, started your career at Trinity Chambers, working closely with Ravi Ramkumar. You have been involved in this as a criminal attorney for 7 years. We are looking at what is good fodder at best, and a real interesting study into case law precedent and how we in fact interpret and enforce what we have on the books. Is that not correct?
Yes.
Let me welcome you to Brunch. It's great to have you here.
It's great to be here, Mr. Bishop.
Right. Rennie is fine. Suniti Maharaj identified something that has been raised before, and let me just get clarity on this. The word subjudice. Explain that first, and then I will ask you why I inquire.
Well, subjudice basically means that a matter is under judicial consideration by the courts in our jurisdiction, in any jurisdiction. So once a matter is active, legal proceedings are active, meaning a warrant has been issued, a charge has been laid, proceedings have been initiated, either civil or criminal, we refer to it as subjudice.
Gotcha.
When that happens, there are certain restrictions on the information that can be reported in the media on those matters for various reasons, mostly because of the prejudice that may accrue by biased reporting or reckless reporting.
So, as long as the process has been initiated, so if the same evening of the incident, Mr. Allen was charged,
yes,
it is subjudice at that point. So anything that interferes with evidence of that scene when bringing it in the public domain by a broadcaster, could I am asking, could that be argued as evidence tampering?
Well, the
tampering or suppression.
Reporting on matters that are subjudice, where you get into problems, is where you report issues with the intention to prejudice the criminal proceedings. So if a media house, and I'm not saying that they have because I don't have all of the facts and I have to hedge everything that I say. If a media house has published material with the intention of influencing the criminal proceedings or prejudicing the criminal proceedings either for or against the defendant, then they would be guilty of a contempt of court, which is reporting on a subjudice matter.
That falls into willful. What you have to prove.
Yeah, you would have to prove that they intentionally publish the material to prejudice the criminal proceedings.
So again, that's another bar you have to climb. Attorney Raphael Morgan is my guest this morning, and we're going to look into this. All right, let's talk about the crime scene, because there is a lot of confusion. And I remember when you and I initially spoke, I believe it was on Friday, we both were in concert that there is misunderstanding as to what happens in a crime scene. To many, it seems obvious, but clearly, when there is a scene of a crime, the police get there, they're doing their function, the media gets there, they want to do their function. Speak to that scene. Who is in charge, and can anything be challenged at the scene? Even if you think there is a conflict, even if you think there is an abuse of any kind, who is in charge of this scene exclusively is my question.
Exclusively, if there is a crime or if there is a search going on, that is the domain of the police officers. And in particular, the officer or officers in charge of the search or the scene at that particular time. And that is so for obvious reasons. For if it is a crime scene, then you are talking about the collection of evidence, the preservation of exhibits, and the prevention of evidence tampering. If it is a search, you are also talking about the preservation of exhibits to be used in, if possible, in further proceedings. So the police having control of the scene and custody of the scene is essential. Media personnel have been allowed onto the scene after the scene has been processed.
But this is, I see, and even then, this is a courtesy.
This is a courtesy that is afforded. It isn't a right, because at the end of the day, the police have to protect the integrity of the investigation process, which would mean that they have to get all the best evidence available from the scene at that point in time, so that they can do their job to the best of their abilities. If they allow foreign persons who aren't skilled in who aren't skilled in crime scene investigation to tamper with the crime scene that may also tamper with the investigation. For example, fingerprints may appear. If we are talking about DNA evidence, DNA material such as skin follicles, such as skin particles, hair follicles may come off of other persons who are innocently there on the scene and may implicate other people when they shouldn't be.
And unfettered access is something that is bandied, but there is no such thing as it relates to the media on a crime scene. Are we clear on that?
That is very clear.
Right. There is no such thing as unfettered access. You get in there, it is a courtesy extended.
Yes.
And I know this. As I said, being a press holder in New York, everything makes it very clear. And I don't know if we have the press passes here. It tells you very clearly you have access beyond the line of a crime scene, but at the discretion of the officer in charge.
I am not sure if they have that policy in place here. However, it is an unspoken rule between the police and the media, as far as I have seen, that the police are in charge of the crime scene. However, you may be allowed to enter the crime scene as a courtesy
at the
discretion of the officers in charge of the scene.
Attorney Raphael Morgan is my guest this morning. So let's go on to what you were looking at. One of the claims made, and I'm going to ask you for your opinion of this. I don't even know if you want to venture there. One of the arguments put forward is it was a case of you, a criminal defense attorney, excessive police use of force, excessive use of force. Looking at the tape yourself, do you, that may not ask you if do you nothing, how do you view what you saw? I mean, what is your conclusion from what you saw as far as specifically in the area of the use of force?
Specifically in the area of the use of force, and I preface this with the fact that I have not seen the unedited footage of the video, but specifically with the usage of specifically on the issue of the usage of force, I myself do not see it as excessive. With respect to how Sergeant Alexander arrested Mr. Allen, but of course that matter is entirely up for the judicial officer,
right?
Who will eventually decide whether yay or nay in that regard.
The Commissioner of Police said that there is nothing to investigate here. He says there's nothing to investigate. We looked at it. Officer Inspector Alexander was operating within his remit. He was doing his business. However, curiously to me, the Police Social Welfare League, they're calling for an investigation. And of course, the attorney for Mr. Allen is also calling for an investigation. Is it enough that the Commissioner, acting deputy, Commissioner in this case, made the statement, I am satisfied, there is nothing more?
Well,
is that unusual for one to ask for one to go extra the Commissioner of Police to investigate this?
Well, speaking as an attorney and as a defender of human rights and civil liberties, there's a maxim that we use in court which says that justice must not only be done but must be seen to be done. So if there are complaints against Inspector Alexander, they must be investigated thoroughly, despite our views. Because as we look on, we went there, but some judicial officer, some judicial authority may form a different view as to the force that was used, and Mr. Allen, in his right, should have that opportunity to bring it before them.
AKA, I would have asked for the same thing. That's where we went with it. You're inside Brunch. Good morning. It's good to have you with us. Let us move our attention now to this despicable, scary, potential massacre that presented itself at the Chaguanas North Secondary School, where the Minister of Education explained, and which was supported by my earlier guest, Mr. Sinanan, that students were prepared to engage in retaliatory shooting that would have presented Trinidad with its own version of Columbine.
Yes.
And this shooting would have had the nation in a completely different mind frame this morning. When arresting these students, because I believe some arrests will have to take place here, my question to you is, what are the likely charges would these students face?
Well, from reading the articles that were published on the issue, the main charge would be conspiracy. Depending on the extent of the conspiracy, it may be conspiracy to commit gang-related offenses, activity, which is contrary to Section, I believe, 9 of the Anti-Gang Act of 2011. Depending on the extent to which they were prepared to go, it may also cover conspiracy to commit murder, conspiracy to wound or shoot with intent to commit grievous bodily harm. There may be charges for possession of firearms, possession of ammunition, possession of firearms with intent to endanger life, those are just some of the charges that they may face.
A lot of these so-called these potential perpetrators would be minors.
Yes.
The demarcation line as to where you charge them as adults and children. Explain that to me, because generally we know that the age of consent sexually and for alcohol and stuff like that, I think is 18. Is it 18 or 16?
There are two pieces of legislation that govern the age of consent.
Please.
So the Sexual Offences Act puts the age of consent at 16. The Children's Act, however, which was published in 2012, for some of the offences relating to sexual offences against children, which is defined under the Act as a person under the age of 18, they put the age at 18.
18 in the case of criminal behavior now, which is what we're talking about specifically here. Is there an argument if they what age moves you from juvenile charge or to adult?
Well, the age of criminal responsibility under our jurisdiction is the age of 7. So from the age of 7, you can be charged with a criminal offense.
Okay, yeah, you have me looking at you from the age of 7. Yes, okay. Thanks for the clarity. My for some reason I had age 12 in my mind. Oh, age 10, I believe it was. But okay, it is 7. From 7 you can be charged.
From 7 you can be charged.
So these charges can be levied in this way. What are the penalties prescribed by law if they are found guilty, let's say, of 2 areas? So one is negligent endangering life, reckless endangerment of lives, and gang activity with the intent to wound and commit murder.
Well, conspiracy to commit murder, conspiracy is a common law offense, and the sentence is at large, meaning it is at the discretion of the judge. That is for most criminal conspiracies. With respect to the gang-related offenses, for example, Section 8 of the Anti-Gang Act, which provides that a person who, whether or not he's a gang member, knowingly assists, aids, or abets any gang member to carry out a gang-related activity, commits an offense and is liable on conviction and indictment to imprisonment for 20 years. So that is a possible penalty that they are facing. In terms of the persons who have recruited them, to be in, reputedly, to become members of gangs, they face sentences of 15 to 20 years. As well as the higher sentence of 20 years comes if they have done the recruiting within 500 meters of a school. So with respect to the firearm, possession of firearm offenses, those they carry penalties on summary conviction of up to 5 years, on indictable conviction of above 10.
You're having brunch on 107.7. Attorney Raphael Morgan is my guest here, and we are talking about what occurred on Friday morning at the Shigwana School and what can possibly follow through on that. If in fact these students were members of a gang as is suspected, would the leaders of this gang under the gang law legislation we have here, would the leaders of these gangs be held culpable for action in the sense of if they in fact recruited these young minds, impressionable youths, got them involved in this? Is there a dragnet that would include the leaders of those gangs, for instance?
Yes. I don't know if you remember the SOE and the various charges.
State of emergency.
Yes, the state of emergency and the various charges that were levied against persons who were alleged to be gang leaders. Some of those actually found their way through the court systems and are still there with persons facing the charge of being a gang leader. Once the police have enough evidence, in this case, if they are able to collate enough evidence that person A is a gang leader, then they would be fully entitled under the anti-gang legislation to go after them for recruiting, for aiding and abetting the children in doing the conspiracy to commit the gang-related activities, providing them with the firearms, bulletproof vests, and all of that.